Canada dropped bombshell for asylum seeker part 2. Last week we talked about the new Bill C-12 that came into force by Canadian government. The bill received royal assent on March 26, 2026. So when a bill receives royal assent, it means it becomes law immediately. And what is unique about this one is that it's retroactive, meaning that it's dated back to 1 year ago, and if possible more than 1 year, because there are elements of it that talks about June 2020. So it's dated back to about 4 years ago now, but it takes effect on Friday, and letter has been coming out on the, on Saturday. I saw some specimen of the ineligibility letter. I will do my best to share it and see what people can learn about that. So after last week, I got a lot of questions and reaction and suggestion. So I tried to summarize all the questions in a simplified way, so that most of the questions, instead of answering one by one, this second part will be able to address that. So if you listen to the last week presentation, then if you listen to this one, if you have questions, this will have taken care of most of the questions that I got in my DM. And also the advice I should always suggest for my followers to just do a favor by sharing it and like it and subscribe, so that it can encourage me to continue to use my time to do this. So last week we talked about the changes in the law. I'll just try to highlight it in order to align the last week with the current week which we are. The major aspect of the law are just 3 or 4 aspects of it, which was a game changer. The first one is the law itself is targeting asylum seekers in Canada. So to put it in context, why is the government making this decision becoming a law? They always track behavior. So when they see maybe abuse or unusual behavior that many certain applicants or claimants or citizen or national of another country trying to take advantage of the Canadian immigration system, the reaction is always to modify the law. This is exactly what they did. The new law says asylum claims must be made within 1 year in Canada. In the past, you can be in Canada for 2, 3, 4 years, if possible more than that, and then your circumstances change and you decide to make a refugee claim. They would rather not look at when you make the claim, but rather than look at the credibility of the claim. However, in the screening form, if you go for refugee hearing, there is always a case management officer that will simplify the main issues for the judge to make the claim. But in my opinion and experience, there is always issue about delaying claim if there are delaying claim. So the onus is on the claimant to surmount that doubt that why is the claim so delay or prolonged if your life is really in danger. But I think this now go beyond that. This talks about more of exclusion rather than addressing the issue of delay making claim. So Delay in making claim affect eligibility in the past, but in the present situation, the delay in making claim even exclude the claimant, make you ineligible to make the claim. So that's the first aspect of the law. The second aspect is that if you come in through US, either border or by air, definitely you are going to be expected to make a claim within 14 days. Anything after 14 days, you will be excluded. However, that one also override the third safe agreement that Canada had with United States. In the past, you have agreement that if your life is in danger from anywhere in the world, if you arrive in Canada and you are going to US to make a claim, you should make your claim in the first country of arrival, or vice versa. If you arrive in US and you are coming to Canada to make your refugee claim, you are expected to make your claim in US because that's the first country of arrival. That's where the issue and the controversy was on third safe country. But there are exceptions. Some of the exceptions are the fact that maybe you have a family member in Canada who is a permanent resident or a citizen, or who is married to you, probably ongoing the refugee claimant. They might give you exception. The border service officer will detain you, interrogate you, interview you, and write a report. And eventually, if you fall within the exception, they will let you come into Canada. So in that context, they are trying to address the issue of third safe country. That, okay, even if you are given exemption to come into Canada, if you don't make your claim at the border, maybe because you are afraid you might be deported back to United States, they now give you a short period of time now, 14 days to make your claim. In the past, if you've not made your claim, you can still be in Canada for as long as it's safe for you, and then if your circumstances change and you want to make a refugee claim, you can make it without consequence of time of making the claim. However, like I said, if you get to your refugee hearing and you are with the judge will determine credibility based on the delay in claim as one of the issues to be addressed as at your refugee hearing. But this time around now, they now put a pressure on you that once you arrive in Canada, you've not made your claim and you come in through the United States, you have to make it within 14 days or you become ineligible. And we'll talk about once you are ineligible, what's your option. We'll talk about that. That's why this law is unique. The law is also retroactive, like I said. It came into effect on June, that's Friday, March 26, 2026, but the effect is effective from June 3rd, 2025. So many claimants that have made their claim last year might deem ineligible, and they will receive a letter very soon. I think I have a copy of the sample of the letter. If I have time, I'll be able to read it, and after the presentation I can share it on my Facebook link for you to read and have an idea, so that you can know how to address it if it happened to you, or if it happened to somebody you know, or somebody that might need it in future before making a wrong decision. So the other one is, why are the concern about this law? There are many concerns because it's unusual, because Canada usually enforcement is not order of the day. There is always compassion, there is always consideration and flexibility. But these days, I believe things has changed. Like they say in the Bible, the king or the pharaoh that knows Joseph is no more. So Canada is changing, and it's changing rapidly. So highlight of some of the concerns when I read the act, because it has become an act of parliament now, and it has become an immigration act. So Canada no longer comply with its international obligation. Why? Because Canada is a signatory to the 1951 convention, and the 51 convention, which is the refugee convention, place no time limit on when to initiate asylum claim. When the convention was conceived and approved and used around the world, it basically did not put a timeline on when an asylum claim should be made. It should not be made under pressure, even though your life is in danger, but at least you should not be rushed to make a wrong claim that, although you might have a credible case, but because of you are being afraid or you have timeline, your case might be refused and you'll be deported to danger. And to give the context why we're saying Canada is no longer complying with the international obligation in terms of refugee obligation, is that the 51 convention was as a result of the Second World War. The Jews mostly were persecuted by Hitler in Germany. So they ran around the world after the war, and then they need a place to resettle. Apart from having a place to resettle, they want future occurrence not to be like this, or something should prevent future occurrence. But if for any reason there is a Third World War, which was the concept in 1951, people running from one country or the other should be able to receive protection from any country they run to. That's why they brought this the Refugee Convention, and Canada obliged and signed the convention that they will use their domestic legislation to comply with this. But with this new law now, is negating the obligation, because a refugee or an asylum seeker must make their refugee claim or seek asylum on 5 basic grounds, which is nationality, religion, political opinion, race, and membership in a particular social group. So those are the standing order for making a claim for being eligible to seek an asylum. But that is now changing now with the new law, saying that time frame is another category which we can now consider as a sixth category. Not even sixth category, because you are even excluded. So the only option you have now, if you are ineligible because of delay of 1 year or delay of 14 days if you come in through the US border to Canada, is that they will give you pre-removal risk assessment. So if you see the concept now, the pre-removal risk assessment is not the same thing as refugee claim. One, the unique aspect of the distinction is that refugee claim give you the right to tell your story orally, because they will listen to you. There will be element of compassion if somebody listens to you one-on-one. But the pre-removal risk assessment has to do with, you have to make, we can't call it a claim, but you have to justify your fear or your risk in writing. And how many people can write? And even if you have legal assistance, can they articulate what you want to say like you want to say it? So those are the challenges here now, that the pre-removal risk assessment is being offered as alternative but it's not a fair alternative because they are not the same thing. And that pre-removal risk assessment itself was designed for people after all options have failed and they claimed they were in Canada because their life was in danger, and because they found them to be non-founded claim, which means that the claim didn't reach the threshold of the 5 refugee ground, which is the one we talk about, the race, nationality, and all others. And more so in 2021, no, 2001, 2002. This is the irony of it. Canada went further, not only to stay on the 51 convention, because in 2001 time has changed, so they try as much as possible to now include another ground, which is, if you are not a convention refugee, you are a person in need of protection. So if you are not making, if your claim does not, your asylum claim does not fit within the 5 itemized ground, you can still make a claim as person in need of protection. Maybe you are a victim of trafficking, maybe you are your sexual orientation, or there are other risks that is danger to your life. However, they were not conceived in 1951. So they created Section 97 under the Immigration and Refugee Protection Act of Canada. If you are not eligible or your claim doesn't fit in within the narrow of Section 96, which is Convention Refugee, you can seek asylum based on Section 97, which is Convention Against Torture. Anything that constitutes torture against your life can constitute a basis for your claim. But now, going back after 2021-22, Canada is now changing the tune now, excluding people, even though there are certain people that were targeted, but that should not be the alternative to solve the problem. So we'll go further and see this thing now. So like I said now, what is pre-removal risk assessment? Pre-removal risk assessment is a process that reviews whether returning an individual to their home country will put them at risk of persecution, torture, or serious harm. Yeah, it looks the same, but it's not the same. It's apple and orange, because this is assessing you when they want to remove you. But the change in circumstances now is new people coming in are being assessed as if they've been here. All other things has failed, and they want to see if they will remove them or not to remove them. Another aspect of it is that when you go for refugee hearing, you have the Immigration and Refugee Board, which is a tribunal independent from immigration, which is going to make a determination. And most of the judges there are well trained, and more so, they have sensitivity training to especially the gender-based persecution cases. On the other hand, the pre-removal risk assessment is being determined previously by immigration officer at the enforcement department prior to September 11. But after September 11, we have Canada Border Services agencies that was created. So it's the Border Services agent that is going to make a determination of the pre-removal risk assessment. And the mindset is different from Immigration and Refugee Board. The mindset is to determine if a law must be enforced, meaning that is this person or group of these people are constituting risk to Canada. That's one. It doesn't matter if they're going to face risk in their own country. if they constitute risk or danger to Canadian society, they will be removed. On the other hand, if they now use refugee process as part of enforcement process, these officers have a mindset of determining if this person is a risk to Canada, or if they are risk, they are going to face risk in their home country. But the definition of risk is different from persecution, because refugee convention was based on persecution, but risk assessment was based on risk. Not all risks constitute persecution. Some risks are general risk, some risks are peculiar risk. But to now make the distinction, it might be a challenging aspect for the decision maker when it comes to referring refugee for pre-removal risk assessment. And we are dealing with human life. If we say it's not true and it's true, you deport them to danger. So that's one of the concerns of this new process. Pre-removal risk assessment is not designed for a refugee determination. It's like building a two-story building when your architectural design has been that it's going to be two-story building, and along the line, after doing the two-story building, you change your mind, you say you want to take it to 10-story building. Yeah, it's not going to be, the foundation will not be solid enough to accommodate a 10-story building, because the concept was different from the beginning. So that's exactly what this law is doing now. You are constructing a 10-story building in mind, and you are using the facility that will accommodate a 1-story building. So it's good. There will be conflict along the way, and then we'll see how it goes. Although, like I predicted, there will be challenges which are started already. They will challenge the law. The unfortunate aspect is that it might take longer time, but I believe the court will still make some adjustments going forward. The other one is that the government can now, which is unprecedented, cancel, suspend, or modify immigration documents and pause or cancel application processing. Initially, you start an application, it's been you paid, and they've started the processing of the application. They let it go through until it's completed. You get your result, yes or no, but they can't cancel it in the middle of the application. But now they have a new power that immigration officer, any other, even pre-removal risk assessment officer, and humanitarian and compassionate determination officer can cancel an application, not even getting it to conclusion, but they can just cancel it, and they will not give you any reason, and they will not notify you that it's been cancelled. So you just be hoping that you have an application in the system which has been cancelled, but they are not aware of it. So these are some of the concerns that has been highlighted in this new law. Moreover, like I said, the specific one that they mentioned is that the government can now cancel, suspend, or change immigration documents, such as the specific examples: work permit. You can apply for work permit, it can be granted, and it can be cancelled. Study permit. Will it be cancelled while you are studying? Will you be cancelled while you are applying? There is still no clarity about that. Visitor's visa. Permanent resident visa. So, is it after visa has been issued at the border, at the visa post, and before you get to the border of Canada, if the application will have been cancelled? It's unknown. So there are a lot of confusion, uncertainty, and lack of clarity with the new law. is really generating controversy and anxiety. Furthermore, cancel or suspend the processing of application already in the system or stop accepting new application. Yeah, that's understandable. If they stop accepting new application, that's understandable. They did that in 2012. Even though they canceled some of the application, they refunded money and they stopped processing such application. That was under the skilled worker program, and they tried to modify it, and that's what later became an express entry, because they are trying to address the delay. Some application can take 5 years, 4 years, 7 years at times, and which they seem to be extreme. But instead of leaving those pool as it is, or as it was then, the government canceled it. They refunded a lot of money to the applicant in 2012, 13, probably to 14. And then another reform came in 2015, which is the current express entry under the economic class. Then, the law also targets certain group. They said this can be done for large group or people at once through a single order, meaning that not if they see a pattern of group of applicants coming from a certain group or ethnic group, they might just issue order and cancel all applications coming from such group or ethnic group, which is very alarming. For example, internal government document suggests that the power were partly designed with country-specific situation in mind. They mention India and Bangladesh, which they link them to a sharp rise in asylum claim from international students between 2003 and 2004, which is exactly what I'm saying. Government always track application. Once they see application coming from a certain group of people and they want to address it, there was no clear mechanism at that time to address most of this ongoing abuse of process. But now with this new law now, if they see group of ethnic group, maybe they came as a student and they've lost all option to convert it to permanent resident, they want to abuse the system and make a refugee claim, then the option will now be they will be ineligible. So they will target that kind of group and exclude them from making refugee claim in order to stop the abuse of the process. So that's another aspect of this new law. Then they justify those singling out group or canceling application or suspending application or refusing to accept new application in the name of public interest. But the term public interest is vague. It's not defined in the legislation itself. It's just saying that the government or the Minister of Immigration can issue a ministerial order in the best interest of the public. But what is best interest of the public is still unclear and is undefined. So we're still waiting for time for things to play out. Also, there is no requirement to notify individual document holders whose document has been cancelled or suspended. That's what I said. You might have an application that is ongoing, but the government might have suspended the application and they are not obliged to notify you. So I think there will still be question and clarification on that. They will likely issue a regulation that clarify all that and make it more clearer than making people guessing, because people have fundamental rights to be had and to get a decision. So you can't just put in an application and you don't even know it's been cancelled and you are hoping. So that will disrupt your plan. So that issue, I believe, will also be addressed in time very soon. The other one is that the rules are too strict in trying to keep bad actors out. The law may also shut out vulnerable people with genuine claim. For example, the unaccompanied children that cannot represent themselves, that cannot even articulate their fear. Previously during the refugee claim process, they would be assigned a designated representative that will act for them. But this law did not make clarity on that. Are they going to have a designated representative to do pre-removal risk assessment? And if they are going to do that, it's not going to be oral process. It's going to be writing. So to get an unaccompanied child to write something would be cruel and unusual. It will be barbaric, because what would they want to say? What do they want to write? What's their level of intellectual capacity? So these are also concerned in the law. Then they now said they recognize the concern that might come up, and then came up with safeguard. But the safeguard will not save the situation, because it might be too late, because the timeline is unreasonable and is not responsive to the main issue. The main issue now is people want to know how easy will pre-removal risk assessment will be compared to refugee claim, because refugee claim, you have the basis of your claim. But in pre-removal risk assessment, there is no basis of your risk, because you just need to justify the risk. And we don't even know the definition of a risk, because risk is general. Are we talking of health risk? Are we talking of persecution? Are we talking of general risk in your home country? If armed robbery is common in your home country, if you come in under refugee convention, you won't be accepted as a convention refugee. But will it be accepted as a risk under the pre-removal risk assessment? There is no answer yet. If you have fear of kidnapping in your country and you run to Canada under the refugee process, except you are personally targeted, it will not constitute persecution. But will it constitute risk assessment basis to accept your claim? We don't know. Thirdly, risk assessment usually give you 15 days. 15 days to fill your form and 15 days to present your document. But under the refugee process, you have 30 days to submit, and you have a length of time to gather your document before you are scheduled for your hearing. So there are a lot of timeline and pressure that will play in this context. Even when you have a credible document, but because of the timeline, you won't be able to get it within 15 days to support your pre-removal assessment application. Will the officer wait for you till you present the supporting document, or will they act based on the 30-day strict timeline? That's another issue of concern that need to be addressed. So government knew this in mind. They now highlighted some proposed safeguard that they proposed, that even though they anticipated that this is unusual, this will bring problem, this will put life at risk. One, they mentioned that in the act now that there is a mandatory review in 5 years. So they recognize that this is unusual. This is going to put people's life at risk. But they will review it in 5 years. But 5 years is a long time. If people are deported to danger, they will have died before 5 years. Even 6 months or 5 days. Some people can die if you deport them to danger. That's one. Second, to assess, that means the review will come in 5 years to now assess how the new asylum eligibility rules have been applied. So you see now, they recognize that excluding people not to make claim because of 14 days from US and 1 year arriving in Canada from any other border, or being in Canada and your circumstances change. They want to see how the law play out, but that's a long period of time. For example, there are people who have been here for training. Maybe they came for specialized courses. They are the highest level of government. They are civil servants, they are military officials, they are diplomats, they are career diplomats. They are here for special training. Maybe their training was 12 months. And after 12 months, they decided to stay for 2 weeks or 1 month as vacation to take rest and explore Canada and see before they depart. But unfortunately, before the 1 month after 12 months, there is a coup or there is a change in government in their own country and they cannot return. So how do we assess this? Is this going to be under pre-removal risk assessment or is it going to be under refugee process? Because 1 year has passed and they are here for genuine intention and their circumstances change beyond their control. So these are some of the things that 5 years will be too long to review if the law really achieves its goal. Also, they said, what happened to those claimants through the pre-removal risk assessment? So the government knew in mind that many people will be shut out with the pre-removal risk assessment because the threshold is higher than refugee process. Pre-removal risk assessment, if you look at the statistic, mostly 90-95% are negative. They are unsuccessful because it's very difficult to articulate the risk. Risk is a very difficult element to prove, unlike the refugee process that give easy checklist on the basis of your claim. Your basis of your claim might be because you are a membership in a particular social group, like homosexuality, you are gay, you are bisexual, and the Supreme Court in 1993 has highlighted and clarified that what you need to look for is innate characteristic. So once you said you have innate characteristic, especially women who are making claim based on gender, that, oh, I've been abused by my spouse and I'm coming here to make a refugee claim, because of your innate characteristic as gender, you are a female. That's why the basis of your claim is coming up. But under the pre-removal risk assessment, there is no such provision for that. So there will be confusion. Even the officers too, probably they might require gender sensitive training. They might require cultural sensitive training. There are many things to come with this new law, and it's going to require deployment of more resources to adjust and adapt to the new reality. Also, how was the document cancellation power has been used? Now they want to know. But that's going to take 5 years to review that. They might have targeted wrong group of people that might be making refugee claim based on the fact that they have genuine reason. It's not because they want to abuse the system, but they have genuine reason. But we won't be able to know that until 5 years. So I believe this will not stand a test of time. The court will intervene and make some clarification and resolve some of these concerns, in my respectful opinion. The other one they said is they will determine whether the outcome has been consistent with the public interest ground set out in the law. If you take 5 years to look that's worrisome, because what is public interest ground? It's not defined. If you are talking of people coming in as a group and becoming a danger to the society, maybe they have terrorist tendency in mind, then we can be talking of justifying public interest. But if you're saying group of students from a certain group or country or ethnicity are using asylum after immigration, after their study, they are now becoming an asylum seeker because they are desperate, they have no option. That's not a justified way of using public interest ground. The best way in that context is to make a strict credibility ground for those kind of bogus asylum claim. And that was done in 2012, especially when refugee claimants from European country were being excluded, when the then minister J.C. Kenny used that and as exclusion clause, that even then they didn't say they should not make a claim, because it didn't go, it was tough then, but not as this. They could make a claim coming from European country, but they don't have right of appeal, and they will not wait for them to do judicial review. If their claim failed, they will be deported. That's more fair than this, that you use just public interest ground to now just exclude certain group of students that are making refugee claim because they came to study. Although I recognize that many will use it and as abuse avenue. However, there might be one or two that are genuine, that their circumstances change. Not because everybody is doing it and it's wrong, doesn't mean there are no genuine claimant in such group. So this we'll wait and see. But the other aspect of it is that there is no provision for the fact that under the refugee claimant process, which is IRB, you have right of appeal, then you have right for judicial review to go to federal court. But in this context, there is no mechanism to appeal a pre-removal risk assessment decision. The only option an applicant or rejected applicant have is to go to federal court for judicial review. But the court will not review the judgment of the officer or the decision maker in this context. They are going to review error in law. And I don't see error in law because it was not even designed for refugee applicants, which is itself is error in law if you go to federal court rather than dealing with the case itself. However, since there is no clarity now, we'll keep waiting and watching, see how things go with this kind of claim that has been refused under pre-removal risk assessment. But the concern is that we are toying with people's life. If we play with it and deport them to danger, they will go and die. And that's not what Canada stands for. So, like I said last week, and I'm saying it today again, this law is a departure from the value, the image, and the name and the reason Canada is known around the world, because they know Canada to be a champion in humanitarian and compassionate grant for the asylum seekers and welcoming refugee claimant, welcoming asylum claimant, welcoming resettled refugee. But now things are turning to a different level that we are not even sure what's coming next after this, because it's becoming that around the globe now, enforcement in immigration is becoming the order of the day or the world order. and is alarming, and this, in my opinion, will encourage more people to go underground. So you are trying to reduce illegal immigrants, but this negative law will encourage more illegal immigrants, because people will be quiet and will not want to interact with the system, and then they will go underground and become second-class citizen, or they become illegal and they stay in Canada, and they might be difficult to fish out because they are not going to interact with the system legally. So I predict that this law will now stand till 5 years to be reviewed. I believe federal court will review it, or Supreme Court will review it, and then give clear instruction and adjustment when necessary. And if 1 year gap will want to be implemented, there should be other way to do that. 1 year is too strict, because they have to make provision for people whose circumstances change. And more so, they also dated it back not only to 2005, not only to 1 year, to June 20. Those who has been in Canada or who has left Canada and returned, especially people with multiple entry, they are not going to look at the last time you arrived in Canada. They are going to look at 2020 June. So this is not only for people who have been in Canada in 1 year. It's extended to people who have entered Canada in June 2020. Either you return and come back, they will use June 20 as a threshold date for you to be eligible to make your claim. So, like I advised last week, before you make any refugee claim now, please, I beg you, look around, consult a professional for you to know if you fall in within the category. If not, if you're going to fall in within the category of pre-removal risk assessment, try and consult and know the criteria before you present your case, because you won't have time. They will have time. It's going to be race against time. So if you have a genuine refugee claim, make sure you first find out if you are eligible before you talk to immigration, so that you don't regret your decision. Thank you for your time. I will likely speak next week on the citizenship controversy, bad citizenship in the United States, going between the president issuing the executive order and civil liberty trying to challenge it, that the law is entrenched in the 14th Amendment of the United States and should be kept alive and well. But I think President Trump is trying to modify or change or try to exclude like this, but we'll give more information about that next week. Thank you for your time.